Welcome, students. Keep your bare axe open, clear your desks, and listen very carefully. Today, we're not just reading the law, we are going to construct the perfect, high-scoring KSLU answer script for the law of agency. I am your professor, and my goal today is to make sure you master exactly how this topic must be presented on your exam page to secure those top marks. All right, let's get right into it.
Now, on the board, you'll see the exact structure your answer must take. 1. Definition, under Section 182. 2. Essentials of agency. 3. Modes of creation. 4. The Freeman and Locker case. 5. The Great Northern Railway case. And finally, 6. Kinds of agents. Look, replicating this exact index at the very beginning of your answer script, that is literally how you capture the evaluator's attention immediately. It signals absolute conceptual clarity. Okay, let's start with Section 182 of the Indian Contract Act, 1872. The exact phrasing from the statute is absolutely critical here. It reads, "An agent is a person employed to do any act for another or to represent another in dealings with third persons. The person for whom such act is done is called the principal." Now take your pens out right now. Explicitly underline the phrases act for another and represent another. Do not, and I repeat, do not summarize this in your own words. You need to cement this concept of representative capacity using the precise words of the bare act. That is how you secure maximum marks. Moving strictly to the essentials, we have 4 absolute pillars you must write down. First, an agreement between principal and agent. Second, representative capacity. Third, the intention to create legal relations. And fourth, please pay very close attention here. No consideration is required under Section 185. I must sternly warn you about this. The absolute lack of consideration under Section 185 is a favorite KSLU trick question. It comes up all the time. While most contracts completely fail without consideration, agency thrives without it. You must highlight this exception boldly in your paper. Don't let them trick you. All right, let's move on to Section 1, Modes of Creation of Agency, where we'll examine the 7 legal methods. Notice the strict distinction we are making here. On one side, we have express agreement. This is created by a written contract or an oral agreement, and it clearly defines the agent's authority. On the other side, we have implied agreement. Now, this arises strictly from the conduct of the parties or the surrounding circumstances. For your exams, I highly advise you to draw a clean, comparative structure exactly like this on the page. Why? Well, it saves you precious time, for one. But more importantly, it deeply impresses the grader by showing an immediate, clear distinction between the spoken word and behavioral conduct. Next, we examine a really vital nuance, estoppel versus holding out. Estoppel occurs when a principal's conduct leads a third party to believe a person is his agent, therefore the principal cannot deny this agency later. Holding out, however, relies on continuous representation to create that agency. You see, while estoppel can arise from just a single isolated act of misrepresentation by the principal, holding out requires a habitual, continuous pattern of representation. Make sure you write these sequentially in your answer. It proves to the examiner that you truly understand exactly where estoppel ends and holding out begins. Now mark this down. I want you to write this case law in a separate boxed format on your exam sheet so it pops right out. Let's do a deep breakdown of Freeman and Lockyer v. Buckhurst Park Properties. The background facts here are absolutely crucial. A director of a company, without actually being formally appointed as the managing director, continuously acted as one, completely with the full knowledge of the board of directors. During this time, he engaged a firm of architects. Now, the ultimate ratio decidendi, the final verdict of the court, was that the company was indeed bound by his act. But why? Well, because by allowing him to continuously act as managing director, the company essentially held him out as having the authority to bind them. The absolute relevance of this case for your exam is that it permanently established the legal principle of agency by holding out. Simply put, if the principal sits silently while someone continuously represents them, that principal is legally bound to third parties. Write this exact logic down. It's absolute gold. So moving on to our 5th mode, agency by necessity. The crucial point here is rigid sequential compliance. There are 3 mandatory steps you need to hit. 1. Real necessity. 2. Impossible to communicate. 3. Good faith action. Listen carefully. An agent must clear all 3 of these hurdles consecutively for the legal doctrine of emergency necessity to legally apply. I mean, think about it. If you can just pick up the phone and communicate with the principal, there is no real legal necessity, is there? On your paper, you must draw arrows between these steps. Show the KSLU evaluator the clear flow of these prerequisite conditions. Okay, underline this next case name immediately to capture the evaluator's attention, especially for a heavy 16-mark answer. Great Northern Railway v. Swaffield. Let's unpack the background facts carefully. It's a fascinating one. A horse was sent by train to a destination, but upon arrival, there was absolutely no one to collect it on behalf of the owner. So to protect the animal from starving or, wandering onto the dangerous tracks, the railway company, acting out of real necessity, placed the horse in a livery stable. The final verdict of the court: the railway company was entirely justified and the owner was legally forced to pay the stable charges. An agency of necessity was validly created. The absolute relevance of this case to our syllabus is that it perfectly demonstrates all three of those hurdles of necessity we just talked about. There was a real emergency to protect the property, it was totally impossible to communicate with the owner in the middle of the night, and the railway acted in pure good faith. It is a textbook example.
Now let's consider the final two modes of creation. First, ratification. This is when acts done without authority are later approved by the principal. Note this very carefully. You must specifically write the phrase "relates back to original act" to secure full marks for this section. I'm serious, underline it. If ratified, the law basically treats the agency as if it existed at the exact moment the agent acted. Finally, operation of law. This is automatically created in relationships like partnership in certain specific family situations. Please dictate this exact terminology directly into your notes.
Moving on to Section 2, Classification of Agents, structuring the 9 legal categories.
Let's structure these meticulously for the exam. We have the general agent, special agent, and universal agent. Mapping out the scope of authority from specific to general to universal. That demonstrates perfect conceptual clarity. A special agent? That's for a single transaction. A general agent handles a continuous stream of business in a particular trade. And a universal agent? Well, they have extensive, almost limitless authority to do anything the principal can legally do. Showing this graduation of power clearly on your paper proves to the examiner that you truly understand the scale of agency.
Moving to commercial classifications, mercantile agents include your factors, brokers, and commission agents. Non-mercantile agents are simply those not engaged in business transactions. Think of an attorney, for instance. But drill this middle definition into your heads right now: the Credere agent. This is an agent who actually guarantees the performance of the third party. So if the third party defaults, the Credere agent pays the principal out of their own pocket. Because of this incredibly high risk, mentioning the extra commission they receive for guaranteeing that third-party performance is absolutely mandatory for scoring points here. Underline it. Do not forget those two words, extra commission.
We wrap up our taxonomy with these final categories. We have the subagent, who is appointed by the primary agent, the co-agent, meaning multiple agents acting for the very same principal, and the auctioneer, an agent who sells goods through a public auction. Listing these clearly and concisely concludes the formal, structured outline required to finish a definitive KSLU exam answer on the kinds of agents. Get these down and your structure is complete.
Now, agency is an absolute, indispensable foundation of modern commerce. Think about it. Without it, corporations literally couldn't operate, and distant trade would just grind to a complete halt. But as we wrap up, I want to leave you law students with this provocative conceptual question to ponder as you revise your notes tonight. If absolute representation defines agency, but Section 185 explicitly requires no consideration, what truly binds the principal and agent in the strict eyes of the law? Is it mere trust, or is it the terrifying weight of fiduciary duty? Think about that tonight. Good luck with your exam preparations. Keep your bare axe close, structure your answers sharply exactly as we've discussed, and you will undoubtedly excel.